If you or someone you love has been diagnosed with an asbestos-related disease like mesothelioma, asbestosis, or certain types of lung cancer, one of the biggest legal challenges is proving that asbestos exposure actually occurred, where it came from, and that it caused the illness. In this video, we'll walk through the process of proving asbestos exposure in court, step by step, so you can understand what evidence is needed and how attorneys build these cases. The first thing to understand is that asbestos lawsuits usually hinge on three core points. First, you must show that you were exposed to asbestos. Second, you must identify the specific source of that asbestos, whether it came from a workplace, a product, or another environment. And third, you need to prove that this exposure is what caused your illness. Each of these points requires strong evidence, and often it comes from multiple sources. Let's start with medical evidence. Without medical proof, even the most compelling work history may not be enough in court. This begins with medical records that confirm you have an asbestos-related disease. Pathology reports can reveal asbestos fibers in lung or tissue samples. Imaging scans like chest X-rays or CT scans can show scarring in the lungs, such as pleural plaques or fibrosis. And perhaps most importantly, testimony from your treating physician or a specialist can help link your illness directly to asbestos exposure. Courts rely heavily on credible medical opinions, so having a doctor who can clearly explain the connection is crucial. Next, we have to establish your exposure history. This means figuring out when and where you came into contact with asbestos. For many people, this is tied to their jobs. Employment records, such as pay stubs, union records, or personnel files, can help prove you worked in certain environments. Job site records can show that asbestos-containing materials were used at the time you were there. If you handled certain products, identifying those products and showing they contained asbestos is a key step. Your attorney may also use public records, safety reports, or even newspaper archives to confirm the presence of asbestos in those workplaces. Of course, it's not just about documents. Witness testimony can play a major role. Coworkers who worked alongside you can testify about the presence of asbestos and your proximity to it. Supervisors can confirm whether asbestos-containing materials were used and whether safety precautions were taken. In some cases, family members can also provide valuable testimony, especially if they recall you coming home with dust on your clothing, something that could lead to what's called secondary exposure. The more people who can verify your exposure, the stronger your case becomes. Documentary evidence is another pillar of proof. Attorneys often look for old company safety manuals, memos, or letters admitting to asbestos use. OSHA violation records or injury reports can show that the company was aware of the dangers and failed to address them. Manufacturer catalogs, invoices, or purchase orders can link a specific asbestos-containing product to your job site. Sometimes, finding these documents requires digging through archives, contacting former employees, or even filing legal motions to get access to corporate records. Expert testimony often ties all these pieces together. Industry experts can explain to the court how asbestos exposure typically happens and why certain job environments carry higher risks. They can identify the type of asbestos used and match it to the fibers found in your medical tests. This expert link is often the bridge between your work history and your medical condition. Another important part of proving asbestos exposure is showing negligence or liability. It's not enough to prove you were exposed. You must also demonstrate that the defendant knew, or should have known, about the dangers and failed to act responsibly. This might mean they didn't provide safety equipment, didn't warn employees, or didn't replace asbestos materials when safer alternatives were available. Internal memos or industry publications from decades ago can sometimes reveal that the risks were well known, even if companies publicly denied them. One of the biggest hurdles in asbestos cases is the long latency period. Asbestos diseases can take 10 to 50 years to develop, so by the time you're diagnosed, the exposure may have happened decades earlier. This makes gathering evidence more complicated, but not impossible. Attorneys often rely on historical research, old job site databases, and interviews with retired workers. In some cases, depositions from elderly witnesses are taken quickly, so their testimony is preserved before they are no longer available to speak. Finally, all of this evidence must be connected into a clear chain of causation. That means showing that your specific asbestos-related illness was caused by exposure to asbestos from a particular product, company, or job site linked to the defendant. This is often done by combining your medical diagnosis, your exposure history, documentation of asbestos use, and expert testimony into a single, cohesive story that leaves little room for doubt. Proving asbestos exposure in court is rarely simple. It requires persistence, careful investigation, and the right legal team who understands both the medical and historical aspects of asbestos cases. If you or a loved one is going through this process, know that there are legal professionals who specialize in asbestos litigation and can guide you through each step, helping you gather the strongest possible evidence. By understanding what courts look for and the types of proof that carry the most weight, you'll be better prepared to work with your attorney and pursue the compensation you deserve. Whether it's through medical records, witness statements, company documents, or expert analysis, every piece of evidence brings you closer to proving your case and holding the responsible parties accountable.